Thank you, Damien.
Well, thank you very much. Like the other speakers, I would like to thank the organizers for putting together this program and inviting me. As the lawyer in the panel, I will focus on the following question. Are existing antitrust rules ready or fit for purpose? Or do we need something else to deal with the issues that are raised by the digital economy? I think the answer may be different for the EU and the US in the sense that EU competition law is probably more flexible or offer more options than it is the case in the United States. But I will focus on EU law because this is the jurisdiction that is the most familiar to me. So I think that we probably don't need any new tools on the substantive side. Procedurally, I think we may need new tools, but on the substantive side, on the substantive analysis, I think that competition law is probably flexible enough to deal with the new challenges created by the digital economy. And I agree with Aviv, many of the issues we see now are not new. We've seen them before, it's just the setting that is slightly different. I think that as far as the EU is concerned, the theory of harm that is used time and time again and was used again in the Google decisions is vertical leveraging. The idea that you have a firm with market power on an upstream market, which is using it to, harm competition on a downstream market. And in the case of shopping, the idea was that Google would use its market power on the search market in order to improve its position on the market for shopping comparison services. As far as the Android decision is concerned, it was essentially a matter of time, which is again a form of vertical leveraging that was seen before. I think the reason why DG like this approach is because it's been tested in court with the Microsoft case, so they feel comfortable with it, and they tend to like it. I think more generally Article 102 is very flexible, and the Commission has never been shy to stretch it a bit to accommodate new cases. So I think really when it comes to the substantive analysis, competition law generally is probably fit for purpose when it comes to digital markets. Now, as you may have seen, there have been a bunch of reports, including one from the European Commission that was prepared by 3 professors. Among the suggestions they make would be the greater use of presumptions, which would lead to some extent to a reversal of the burden of proof in some cases. So when there would be prima facie evidence of wrongdoing, then it would be for the dominant firm to come up with an explanation about why they're doing what they're doing. So that would be, I think, quite a shift. Whether it will be implemented by DG Comp is another story. I think another idea that is getting increasingly popular is that zero pricing may be exploitative, which sounds quite counterintuitive, except that some are suggesting that indeed consumers, even when the price is zero, don't get the full value because they're giving away data and so on and so forth. So that's it for the substantive analysis. Now, where I think we may need more changes is at the procedural level. When I was a full-time law professor for 10 years, I was much more interested in substantive analysis than procedure. Now, as a practitioner, I'm actually increasingly interested in procedure because I think it has a very significant impact on the outcome of cases. Now, the difficulty we have with existing procedure, at least in the European Union, but it may be true elsewhere, is that it's very slow. The big tech cases take about 5 to 10 years to find a solution. It's the case for good and bad reasons. I think the good reasons is the need for due process. You want to make sure that your decision is evidence-based, but also there can be bad reasons, poor management. Sometimes nothing happens in a case for many months and you wonder why, but it's very slow. And it's too slow, I think, for both complainants and defendants. For the complainants, of course, it's very slow because, if you have to wait 8 or 9 years to get a decision, it really doesn't help you if you are a victim of anti-competitive behavior. But also for the defendants, it's not ideal at all. I mean, to be investigated for many years can be a sort of, necessary hassle, especially if there's no wrongdoing. Now, there's a sort of urban legend whereby Brussels would be a good venue for complainants. It's actually not true. I mean, my experience as a complainant in some cases has been very frustrating. 90% of the complaints don't go anywhere, and you don't even get feedback from the Commission. They just die out, basically, because the Commission will just pick a few cases without really explaining why your case, that seems to be reasonable, is not looked at. Instead of basically adopting a non-infringement decision, they just let things die out, which is, I think, very frustrating. So what could we do about it? I mean, I think that we need a different system, and I've been thinking about what it could be. I think one thing we could do would be to have time limits. We have time limits for mergers, for example, and that functions pretty well. Of course, you will tell me that in mergers, the parties are very keen for the procedure to go fast because they want to clear the deal. Whereas in abuse cases, the companies might be more resistant, but I think still that putting some time limits could help the process. I really don't see why you need 5 to 10 years to process a case. It's just ridiculous. So if the Commission is not able to produce faster decisions, then I think you need some institutional constraints on them. Another possibility, which I think I would prefer, would be for the Commission to take a decision or a first level decision after 1 year. So assume there's a complaint on the 1st of January. The Commission would have to decide formally by the 31st of December whether they will proceed with the case, and in that case, put the proper resources on the table, or simply dismiss the complaint and adopt a short decision. It could be 5 pages long explaining why they're not pursuing the complaint. What you see now are many cases that are in a comatose state, if I could say so, whereby a complaint was filed 2 or 3 years ago and then nothing happens. You don't know, and once in a while you get a request for information, you have the impression it's sent to keep the case alive, but there's just no work done on the case. I don't think it's good practice. A third solution, and I don't think any of these solutions, by the way, are mutually exclusive, would be to make greater use of interim measures. We have interim measures in the EU. Most national competition authorities can also impose interim measures, but the record is not very encouraging. In the EU, it's almost impossible to get interim measures, which I think is unfortunate, because in some cases that could be helpful. Now, just a final remark. 1 minute, okay, perfect. Some of the reports that have been prepared, such as, for example, the Furman report, which was commissioned by the UK government, and to some extent the Stigler report that came out recently, don't seem to be very optimistic about the use of antitrust law in digital markets, for some of the reasons I've mentioned. It's slow, it's also very fact-specific, and the remedies can be a problem. Commission decisions, for example, including in the Google cases, have been very harshly criticized by the failure to adopt what is perceived as good remedies. What they're proposing is something different. For example, the UK, the Furman report is proposing the creation of a digital unit, which was supported by the Prime Minister in a speech 2 days ago. I realize she's a lame duck, of course, but it's still interesting that she was supporting the idea. And then the use of codes of conduct. I'm not that keen on codes of conduct because it looks like a full employment act for lobbyists. So I would still prefer to use antitrust solutions. In the EU, I think we will see more regulation. There's already one which has been adopted, which is the platform to business regulation, which is trying to address some of the concerns that were raised by some of the practices of online platforms. Yeah, and I will stop here. Thank you very much.